We are going to go ahead and jump in. Thank you all for joining for this virtual panel discussion on the future of water after the recent Supreme Court cases of Sackett versus EPA and Arizona versus Navajo Nation. Welcome to this webinar that is a program of the Beaver Institute's Beavers Uncovered, which is a webinar series on underexplored topics curated by Dr. Bonnie Gulas-Wroblewski and Beaver Institute. We are incredibly grateful for the amazing panelists who have agreed to participate in this discussion today. So just a little bit about our organization. Beaver Institute is a national nonprofit providing the tools and skills for climate resilient communities to coexist alongside beavers and the bountiful ecological and economic services they provide. We are here to steward the embrace of beavers across the landscape through our programs and resources. This webinar series, along with our Beaver Corps Wetland Professional Training Program, are an integral part of our strategy to educate the general public and to expand beaver consciousness and beaver-human coexistence across North America. This webinar series in particular looks to weave disparate experiences, scientific, cultural, social, plural, in Beaverland and gather us in a virtual imaginary of possibility and opportunity. Looking to Beaver, we intend that our activities and actions as an organization create dams of knowledge, serving as a bridge for those who need it, as well as creating intentional channelized networks of community, empowering and supporting each other toward the collective goal, that being the protection of beaver for the benefit of all living things. We are grateful to have the Theodore Roosevelt Conservation Partnership as a partner for this panel. Their mission is to unite and amplify their partners' voices to advance America's legacy of conservation, habitat, and access. And they are fulfilling part of their mission right here with us today by being a part of this webinar. So without any further ado, we have a lovely big agenda on our discussion for today. So let's just dive in. This webinar resulted from conversations with multiple folks over the summer, actually inciting originally with Alex Funk, who was going to be on this webinar, but is experiencing the illness that so many are catching from their kids. So he's not going to be here today, but his associate will be taking his place. But this incited out of a conversation that we had originally out of these Supreme Court cases of where do we go from here? Particularly that conversation started with the ruling on Sackett versus EPA, as it was seemingly devastating for those working toward not just wetland protection and restoration, but expansion. This panel discussion was born from the desire to create a space to share perspectives and information on what this means, and not to rehash the results in a matter of chagrin, but look at it in the face, to rise our heads, extending like turtles out of our shell, and look towards what's next. What does this ruling allow? Concurrently, as much as we think about ecosystems and our more than human kin at Beaver Institute, we also think about humans, from headwaters to faucet. And the faucet, the water that provides and sustains life, is central to another Supreme Court ruling from last session, and that is Arizona versus Navajo Nation. This particular case is nestled within the complex and often contradictory stranglehold of water rights for the Navajo Nation, whose sovereign land covers multiple states, which means managing multiple layers of bureaucracy and policy, which is why we are so grateful and fortunate to have Dr. Crystal Tulley-Cordova and Michelle Brown-Yazzie with us today to illuminate and expand upon this topic. This particular case was originally filed 20 years ago, and the context extends back to the Treaty of Bosque Redondo and the horrific Long Walk. Water rights and water scarcity are acute for all communities in the West, but especially for tribal nations. The Navajo Nation's Department of Water Resources says that between 30 to 40% of the population of Navajo Nation does not have access to clean, reliable drinking water. And the U.S. Environmental Protection Agency says that 15% don't have access to piped water at their homes. So today here, right now, we're going to weave a high-level conversation on the future of water for ecosystems and humans. And throughout, as a moderator and someone who is not an expert on water policy and law, I will attempt to lean toward silver linings and to question what can you, I, we, all of us do about this? And as ever, how might Beaver help or not? But first, let me introduce you to this esteemed group of experts we are privileged to host in our virtual lodge for the next hour and 5 minutes. Before I do that, I'm going to take a sip of water because one moment. Dr. Crystal Tulley-Cordova is a principal hydrologist in the Navajo Nation Department of Water Resources, Water Management Branch, and an enrolled member of the Navajo Nation. Crystal currently works on securing water rights and developing water infrastructure projects for the Navajo Nation. She has worked collaboratively with Navajo Nation partners on water-related research since 2013. Her past research consisted of 3 projects conducted in collaboration with the Navajo Nation Water Management Branch, Navajo Tribal Utility Authority, and Navajo Environmental Protection Agency. In 2021, she was awarded the American Indian Science and Engineering Society Professional of the Year Award and the University of Arizona Agnes Nelms Hari Tribal Resilience Leadership Award. She received a doctoral degree in geology and an interdisciplinary graduate certificate in sustainability from the University of Utah. She has received a Master's of Water Resources and Hydroscience and a Bachelor of Sciences in Earth and Planetary Sciences from the University of New Mexico. Dr. Joel Sholtes is a water resources engineer and fluvial geomorphologist who teaches in the University of Colorado, Boulder, and Colorado Mesa University Civil Engineering Partnership Program. His research focuses on how restoration of stream and river systems influences how they interact with water and sediment. He's currently studying this on headwater stream wetland corridors in Colorado, slated for process-based restoration treatments, with the goal of beaver recolonization. The goal of this project is to understand how this restoration approach influences stream flow and sediment storage. Christian Fauser, who is gratefully here today in absence of Alex, is the Theodore Roosevelt Conservation Partnership's Western Water Policy Associate. In this role, Christian is working with watershed organizations across Arizona and accessing and implementing public funding sources to support aquatic ecosystem restoration and drought resiliency projects. Christian is especially excited by a growing interest in beaver reintroduction and beaver dam analog projects in the state. Christian recently graduated from Northern Arizona University with an MS in environmental science and policy. His research worked to inform state and federal invasive fish management efforts on the Upper Verde River in central Arizona, the only remaining perennial free-flowing stretches of river in the arid state. An early career water policy and conservation professional, Christian has worked on a wide array of projects focused on conserving rivers and aquatic species through and for the benefit of present and future generations in southwestern United States. Jeff Lapp is the Senior Science Policy Advisor at the National Association of Wetland Managers. Prior to joining NAM, he spent over 32 years with the Environmental Protection Agency, primarily in the Wetlands Program. Starting out in the Wetlands Enforcement Program in Region 3, he conducted many wetland inspections and has testified as both an expert and fact witness in civil and criminal federal cases. For the past 12 years, Jeff has been the chief of wetland branch at EPA Region 3, overseeing both the regulatory and non-regulatory wetland programs, the Ocean Dispersal Program, and the Watershed Resources Registry. He also has been a host of acting positions, including Deputy Director for the Environmental Assessment and Innovation Division, Deputy Director for the Office of Public Affairs, the Wetlands Regulatory Branch Chief at EPA headquarters, and the Wetlands Technical Enforcement Lead at EPA headquarters. As an avid botanist and horticulturalist, Jeff designed and constructed the EPA exhibit at the Philadelphia Flower Show for 29 years, earning several awards. Michelle Brown-Yazzie is an enrolled member of the Navajo Nation and is of Salish and Korone, Ogallala Lakota descent. She received her JD in 1999 from the University of Iowa College of Law and her BA in English and Political Science in 1995 from the University of New Mexico. She has practiced law since 1999, and prior to her return to the Navajo Nation Department of Justice, she served in the judiciary for 10 years, including as chief judge for the Mescalero Apache tribe and for the Pueblo of Isleta. Her positions include staff attorney and senior prosecutor for the Navajo Nation, prosecutor for the Gila River Indian Community, assistant district attorney for McKinley County, and is a partner at Smith and Brown-Yazzie LLP. She also served as deputy cabinet director for the New Mexico Indian Affairs Department, appointed by then New Mexican Governor Bill Richardson, executive director of the Navajo Nation Washington office, appointed by then Navajo Nation President Kelsey Begay, and legal counsel to the Navajo Nation Office of the President and Vice President, also appointed by President Begay. She is licensed to practice law in the Navajo Nation and the state of New Mexico, in the federal district for the state of New Mexico, in the U.S. 9th and 10th Circuit Courts of Appeal, and the United States Supreme Court. So we have an incredibly esteemed group of individuals with us, and I am really excited to jump right in. I'm just going to check our chat really quickly to make sure that, and just so you know, feel free to introduce yourself and say where you're coming from, so everyone's aware. And the chat is open as well as the Q&A. So feel free. I'm going to stop sharing my screen for a moment and bring myself back to you all. All right. So there are going to be many acronyms used today, and we will do our best to share those in real time. And there will as well be historic cases that will be referenced throughout, and we'll attempt to link you in real time. And to answer a question, there will be a recording of this made afterwards to the public to watch. I'm going to jump right into it. So I'm going to hand the mic over to Jeff Lapp to enter us into this conversation via Sackett versus EPA. So Jeff, take it away.
Thank you very much. Good day to everybody. Hope everyone's doing well and safe. As everyone's well aware, the Supreme Court sent a decision out this summer that was significant to the extent of jurisdiction federally for waters of the United States. We at NAM have been, the National Association of Wetland Managers, sorry, I tend to use acronyms a lot as well. We have been dealing with lots of states and tribes on the fallout from that, looking at various ways to sort of overcome the gap that is created from traditionally federal regulated waters and those waters that may not have jurisdiction at either the state, tribal, or other types of jurisdictional levels. For those who may not be aware, but I think most on the call are, is EPA just promulgated or revised their 2023 definition of waters of the U.S. Essentially, with that rule, they removed the use of a significant nexus analysis, which was under Judge Kennedy's opinion in Rapanos, and they also removed interstate wetlands as a regulated class of wetlands solely by the fact that they are interstate, as well as removed adjacency. And so beyond that, the rule really didn't say a lot, in my opinion. I think that the devil for a lot of these things is going to be in the implementation details that we see coming out of the Army Corps of Engineers and EPA. There is some history to this. Post the Rapanos decision, the agency does have a process where they identify relatively permanent waters. That was part of Judge Scalia's opinion in Rapanos. So there is a field process that the Corps has used, as well as EPA. However, when they passed or updated the new rule, finalized it, they didn't really reference that. So hopefully that will be something that we'll find out in the next couple months. I think the other thing that we're all waiting to hear from is how they are going to identify in the field relatively indistinguishable, and whether that will be a hydrologic indistinguishable, whether it will be a permanent one, whether it will be a temporal one, i.e. flooding. And then the last is sort of this connective issue, whether there needs to be a discrete connection between wetlands and a relatively permanent water, or whether that connection could be something such as shallow subsurface flow, that where you would have in a riparian zone, a wetland, and there may be hydrologic communication between the relatively permanent wetland, or the relatively permanent water, and the wetland, and how long that permanence has to last. So those are all things that certainly we are all interested in finding out, because ultimately that's going to depend on if there's any augmentation to state regulations that may need to be undertaken, or tribal regulations, in order to fill those gaps, or to understand what the true impact on the ground is of the Sackett decision. I've seen some estimates out there that are millions and millions of miles apart in ephemeral stream lengths. I also think that this is an issue that is geographically disparate. For example, in the southwest part of the country, in the western part, it is a very different hydrologic dynamics than we're seeing, that we may have in the east and with our hydrologic drive of these systems. So that's something that we're going to have to look at as well. And then I know Adam and I talked, and at NAM we've been having a lot of discussions of what is the alternative. If these areas that no longer are jurisdictional under the Federal Clean Water Act as waters of the United States, are there other mechanisms that can be employed to provide protections for these? And some of the examples that we've brainstormed, I don't think that there's any landing on any of this until we hear more from the agencies, but things like if you have a TMDL analysis and you look at your hydrologic budget and you're including wetlands or other aquatic resources that are no longer considered jurisdictional, can you include them in your dilution accounting for what the limits are at end of pipe? The same thing with MS4 and stormwater controls. Prior to Sackett, there was a much broader, I think, look at what type of aquatic resources could be used in your analysis of flow and budget. If they're no longer regulated, what could be, a storage facility today, i.e. a wetland system that's not regulated, could be a paved parking lot tomorrow if there's no protection on that. And then lastly, and I think, I'll turn this over, or we can open it up for questions, whatever, Adam, your thoughts are, is, as we talked about earlier, are there ways that we can make up this difference vis-a-vis state or local or tribal regulations? So I think that's it for now, unless there's anything that I missed in our discussion, Adam, that you'd like me to address.
That's great. Thank you, Jeff, for that sort of high level expounding upon. And I want to hand this now over to Christian, who's going to sort of take it a bit further and talk about some more implications.
Yeah, so in terms of the immediate implications of the Sackett decision, we have now seen and are experiencing a significant loss of federal protections for streams and wetlands. And this is inherently true for states that have long relied on the federal 404 program for stream and wetland dredge and fill regulation. And while mapping and estimates are still ongoing, it is highly likely that more than half of this nation's streams and wetlands are going to lose federal protections as a result of this decision. In arid states like Arizona and New Mexico, this number is actually more like more closer to 80%. Largest impact of this decision is going to be in states that either lack or have a limited regulatory program for stream and wetland protection at the state level that would otherwise account for this loss in federal protection. And this reality encompasses about half of U.S. states. But on an optimistic note, you see states like Illinois, Colorado, and New Mexico actually taking the lead on developing their own state-level regulatory programs. That said, that doesn't mean that these states aren't experiencing their own set of hurdles in trying to institute these programs, be that state legislative processes, lack of capacity, and lack of funding. And so in terms of next steps in trying to fill in these gaps, we need to be urging states to consider the development of these type of state level regulatory programs. And as organizations, as individuals, as tribes, as municipalities, we need to be supporting sweeping advocacy for these types of efforts. Groups like Clean Water for All, TRCP, and many other organizations are working tirelessly on the ground to coordinate regional efforts to this end. And it's important to consider that this isn't actually going to be enough. To kind of reverse the loss of protection, we need to be advocating for federal legislation to amend the language of the Clean Water Act to strengthen protections for streams and wetlands while also clarifying the scope of the Clean Water Act. And then in terms of more localized efforts, in terms of filling in the gaps, we need enhanced funding and capacity for voluntary wetland conservation programs like the Wetlands Reserve Program and the North American Wetland Act grants. We need there to be financial incentives for developers to limit their impacts to wetlands, and we need to increase resources for states working to develop their own state-level regulatory programs. And then lastly, I can kind of just touch a little bit on the messaging post-Sackett. It's important to note that the Waters of the United States discourse is actually not that helpful in terms of moving forwards towards finding a solution, given that it is pretty dominated by regulated industry and agriculture. We, again, as organizations, as people, we need to be reasserting the many values of wetlands and streams that exist outside of them just being habitat for fish and wildlife and a source of clean water. These wetlands and streams actually provide natural solutions to mitigating the impacts of floods, fires, and droughts. TRCP, we recently conducted a survey that found there to be strong bipartisan support for federal protection of streams and wetlands that are critical to fish and wildlife. And that said, and to conclude, we need outdoor recreational businesses and fishers and anglers to step up and encourage support within congressional leadership towards finding solutions. And to kind of summarize all of this, moving forward, we need broad support for programs and at the state level and actions to amend and strengthen the Clean Water Act. And without significant progress to these ends, we are likely to continue to see a dramatic loss of streams and wetlands that are already dwindling here in the 21st century.
Thank you, Christian, and thank you, Jeff, for those sort of high-level overviews. I'm curious, a question that I have, and just from my cursory research into this and understanding, would it be fair to say that the results of this case now give more power to states to make sort of adjudication, or is it more of a double-edged sword? I imagine it's more complex than that, but I'm just curious to hear your perspectives.
Yeah, I'll start, and I'm sure and Christian can follow in. I think it's kind of a double-edged sword, and I think Christian alluded to it during his presentation. Is there are some states that recognize that this affects their aquatic resources, their ability to withstand floods, their ability to have clean, potable water supplies, and so are actively trying to determine what the gaps are in between federal and state jurisdiction. As Christian said, many states prior to this had relied on the federal Section 404 program as kind of their backstop. That backstop's been pulled. However, the inverse is also true, is several states do have regulations that state they can be no more stringent than the federal regulatory authorities. And so therefore, they're going to actively back off of the strength of their programs. And some are getting pressure to do that as we speak. We are at NAM hoping that we can incentivize states and tribes to take a more active role by being authorized to run the 404 program. We're trying to look at ways for, to make up the resource deficits that states and tribes have to be able to undertake this program. And currently we're having a lot of discussions both with our members as well as with EPA at the headquarters level, and trying to actually the 404G, which is the assumption of the 404 regulatory scheme from EPA and the Corps, is out for comment right now. So that would be something that I would encourage the folks online to comment on as well, about the need for strengthening those programs. Christian, I'll turn it over to you.
Jeff, I don't think I have too much to add. You definitely covered the bulk of it, but I will just say leaving all of this freedom kind of up to states to redo these regulations to make decisions for wetland and stream protection brings it back to what is occurring at the advocacy level and what these constituencies of these politicians are actually wanting, which brings it back to just why our voices are important, why organizational voices are important, and why it's important to be having webinars like this to show what is actually occurring on the ground, and what best steps to next take, so that we can protect these valuable resources.
Thank you. And I just put a link in the chat for more information about how to make a public comment. I think on that side of things, looking towards the future and knowing that this new document came out on waters of the United States, referred to as the acronym WOTUS, if it comes up here, as I've talked to a lot of folks in policy and recognizing that sometimes what's not mentioned and is just as important as what is. So what's not in the new definings of the waters of the United States that might portend a silver lining here, if any?
Christian, why don't you go first this time? You can switch it off.
Well, what's not in it, I'm not sure necessarily constitutes a silver lining, at least in the conversations that we're having over at TRCP. Basically anything that is not directly connected to waters of the United States, being navigable, as I understand it, surface water, perennially flowing waters, which wetlands are often not. They are disconnected, and it's hard to make that determination of where wetlands begin and these waters end. And then as well, you just do have isolated bodies of fresh water that are not directly connected to those sources of water. And these sources of water that I'm mentioning are not actually covered under the new ruling or mention.
Thank you.
Yeah, I think you're spot on, Christian. I'm not sure if the lack of information in the final WOTUS 2023 WOTUS rule language is a silver lining, or whether it's that the agencies are gun shy at this point and afraid to come out with a position. So it's concerning that they didn't specifically say how they're going to be regulating these wetland systems that are next to relatively permanent waters. It was concerning that they didn't come right out and say, look, we've been doing this for 17 years. This is how we've done it post-Rapanos, so we're going to follow that same methodology. I mean, the court seemed to be begging them to basically say, take Scalia and run with it. And yet that didn't come out in the rule. So what I think we're all hoping is that this isn't a sign of just almost, a syndrome of that they're almost afraid to do anything because litigatorily they've had so many failures and run up against such walls from both Congress as well as the courts in the past couple of years. That being said, if I was going to try to identify a silver lining, I mean, in the past, the agency has regulated floodplain wetlands and used things such as berms and levees as not as separating structures, but as proof that there was flow during flood periods, because that's why and how these are there. So they could, in essence, say that these are indistinguishable, and our proof is because of these berms, because there is a flood event which causes the deposition of this material in order to create those berms naturally. It would be nice if, because they didn't mention that you needed a discrete conveyance or some type of direct feature on the landscape to connect a wetland to a relatively permanent water, that they're looking at things like shallow groundwater and hydrologic connections. But until we see that, it's hard to know if that's what their thought process is, or just that they limited the language in the current final rule in order to minimize the litigative risk that they may undertake by doing that. So,
thank you, Jeff. Thank you both. I'm going to move on to our next topic, knowing that at the end, after these presentations, there's going to be sort of an open forum where we'll be able to expound upon and ask some more questions. So thank you for building out this first pocket of our discussion. And as I mentioned, I'm going to build us a beaver bridge over to water rights. at the intersection right now with Dr. Joel Sholtes, who's going to talk a bit about his work at this particular intersection. So Dr. Joel Sholtes, I'll hand this over to you.
Great. Thanks so much for having me. Happy to be here. Yeah, I'm going to tell you a little bit about what's been happening in Colorado where I am related to beaver restoration and water rights and wetland restoration. And I'm going to just share a few slides real quick to illustrate this. And a lot of the work in Colorado, restoration of streams and wetlands happens for a number of reasons. A lot of our focus at the moment has been on these headwater systems where we've had incision and widening happen, lowering the water table, essentially draining this wetland. This could either happen indirectly through impacts like grazing or directly through channelization. And a lot of the restoration work is trying to build this back up, build this system back up, both through capturing sediment, restoring vegetation, and restoring beaver. And this graphic down here shows we'll say intact system or a restored system that has active beaver ponds. The water table is higher, closer to the surface. We've got surface storage of water, and it's a wider corridor as well. You'll also notice that it's greener. And there's water that's kind of stored in these ponds. And when we think about greenness and we think about ponds in Colorado, we think about where's that water going? Because in a lot of our systems, we in Colorado track every drop in many areas. And here's just another look at what this restoration looks like. This is a stream that to maybe the untrained eye looks pretty nice, but it had a lot of beaver in it historically through historic analysis and not kind of functioning like it had. So here's post-restoration. This is work from Ecometrics, where a beaver actually came in and took some of those structures that people put in, the human beaver analogs, and beaver recolonized the system and created these more lush, widespread, hydrologically dynamic and connected system. And in Colorado, we're struggling with this. What constitutes a dam? We know when we build a reservoir or an impoundment to take water, there's a legal process for that to decree a water right, adjudicate it, assign a cubic feet per second over a season for that water to be stored or diverted. And that's very well established in Colorado and other states where we have a water rights system in the West. But beavers have been out here for millennia or millions of years. And when humans go in and recreate these structures and attempt to restore these systems, this raises we'll just say legal hackles of the water user community and water rights community. Are we storing water and taking water rights from downstream users? And there's been legislation in Colorado that was attempted to address this, and it was fostered by the environmental community. There were restoration projects that were getting hampered because the local water administrators, we have these basin by basin water districts that review projects like this that could impact water. And some of these projects were not getting permits or being shot down essentially because of concerns about impacts on downstream water rights. Are we storing water that doesn't have a water right designated to it? Are we evapotranspiring water that might not otherwise be evapotranspired and leaving the system? And so this legislation in Colorado that came out last year was attempting to address this by identifying a historical footprint based on a kind of a geomorphic floodplain definition that said, okay, if you're restoring a riverscape or a stream or wetland corridor within this historical footprint, then there is we're going to call it, I got to look up this word, a presumptive rebuttal. Our water lawyers can help me with that one. So I'm a hydrologist, not a water lawyer. But the idea there is that there's essentially some additional legal protection for this, where a downstream water right user can't just sue and stop this project. A judge gets to review it and say, you know what, this falls within the legislation. So we're not going to consider this an injury to downstream water rights. This definition, this historical footprint definition, ultimately did not get passed, and a smaller legislation that just targeted restoration, where we're manipulating the channel and doing some work, we call it kind of minor activities, riparian restoration, that sort of thing, would not be considered an injury to water rights. So this kind of beaver restoration, this wetland restoration type work was left out of that legislation and is still kind of hanging in limbo. And where we're at, and I'll stop there with my slides, is essentially this I'll say conflict between the water rights community, where they're concerned about essentially a limitation on their ability to defend their water rights downstream. And then also on kind of the other hand, we have this lack of science. I will say there's certainly a lot of science out there on how wetlands mitigate and work with water, how much water we're storing underground and in the surface, and how much evapotranspires. But in Colorado, there's, I would say, a lack of science that brings all that together to say, how do these kinds of projects actually influence stream flow? We have a lot of, at least from a conceptual level, understanding that, yeah, well, if we store more water in the landscape, then there's more water later in the season. We're potentially perennializing these streams. But how does that trade off with evapotranspiration? And what is the actual hydrologic signature of restoring these systems? And so that's the effort that I'm working on in Colorado, where we're actually going out and instrumenting these sites to gauge stream flow and measure where we have surface and subsurface storage before and after restoration, to get many years after that process to see what is the long-term impacts as these projects mature and develop on hydrology. A, for the ecosystem services that we think they have, and B, for the potential water rights implications.
Thank you, Joel. And I do have a few questions, but I also want to make sure that we have enough time for all of us to sort of commingle in our responses and thoughts, and to create that space. So I do want to take this the water rights and jump right into the next part of this discussion, particularly as it relates to Navajo Nation and the recent Supreme Court ruling, how it affects communities, what's happening on the ground, and what comes next. So I want to hand the mic over to Yazzie Brown, who's going to give sort of a high-level overview and has, I think, some stuff to share with us.
Yes, good afternoon, all. Thank you for allowing me to be part of this panel. This is great information, great discussion to be had. I'm going to go ahead and do a kind of a quick overview of the case Arizona v. Navajo Nation, which was before the Supreme Court this past year, and the decision came out in June of this year. So I do have a presentation, and let's see if it's working. Okay, there we go. So I know Adam kind of covered this in the intro. The case was actually filed back in 2003. And this is after decades of the Navajo Nation trying to work with the U.S. government to address its water needs, including having filed interventions in the Arizona v. California case for the nation to have its water rights identified and quantified from the mainstream Colorado River. And so as a result of that happening, the Navajo Nation, my understanding, has filed this case to try to put that pressure on the U.S. to help the nation address its water needs. As soon as the case was filed in the U.S. District Court for the state of Arizona, the district court did dismiss the case, and it actually dismissed the case twice. The first time was stating that the Navajo Nation didn't have standing under NEPA, and also that the U.S. government was immune from suit. So twice the district court reversed and remanded the case back to the district court. The Ninth Circuit did agree with the lower opinion about the Navajo Nation not having standing under NEPA. However, the Ninth Circuit, in its more recent opinion, did find that the U.S. government owed a duty to the Navajo Nation as part of its trust responsibility. The Navajo Nation, the relief being sought from the nation was for there to be an assessment done of the nation's water needs, and that a plan be that there be a plan established to address those water needs. After the second reversal and remand to the district court for the state of Arizona, the state interveners filed a petition. They were the first to file. And then, of course, the U.S. also filed a petition to the U.S. Supreme Court for cert. Oops, let me go back a little bit. So the Supreme Court heard oral arguments in March and then issued an opinion in June of this year. And as soon as the opinion came out, there were different articles that were posted like within seconds. Some of them were stating Supreme Court rules against the Navajo Nation's request for water rights. The Supreme Court rejects bids from the Navajo Nation. The Supreme Court denies Navajo Nation water rights claims. So I just point this out because it did cause some panic on the Navajo Nation. Our Navajo members were very concerned about the case and the opinion from the Supreme Court. We got a lot of calls, our leadership got calls, with members believing that we lost our water rights in this case. And that really was not the case. So we've had to do a lot of community education on what the ruling really was. And the ruling really was focused on the U.S. government's trust responsibility. So again, the nation had specific relief that it was requesting. We were requesting an assessment and a plan to address our water needs. The Supreme Court decision, it was a slim, we say that it was a slim decision. It was a 5-4 decision, and it stated that the U.S. does not have a treaty-based duty to assess the Navajo Nation's water needs, nor to develop a plan to secure needed water for the Navajo Nation. So that's what we've been, educating our members, that this really was about the trust responsibility, and we did not lose any water rights in this case. So in regards to the majority opinion, the Supreme Court did say, did cite the United States v. Hickory Apache Nation case, which is a 2011 case, that a tribe must establish that the text of a treaty, statute, or regulation imposes certain duties on the United States. And in our case, the Supreme Court pointed out that the 1849 and 1868 treaties did not expressly impose a duty on the United States in this case. And so there's more quotes here on this slide to Justice Gorsuch in the dissenting opinion points out, that there was a history that it seems like the majority opinion didn't take into consideration. And so I just want to point out that a lot of people don't know that the treaty was entered into after the Navajo 100 miles, and then they were imprisoned.
I think we lost you a bit there, Michelle. If you're able to reconnect, is a really vital point too, I know. I think for this moment, let's see here.
Did I?
Are you still with us? Oh, there we go.
I'm so sorry.
No worries.
I was at the good part as well.
Yes.
Let me get back to it. Okay, can you see my presentation again?
Yes.
Okay, so the treaty was entered into, after, some very stressful and traumatic times for the Navajo people, but also the treaty itself it was actually translated from English to Spanish, and then Spanish to Navajo. And then, of course, the translation went from Navajo to Spanish and then back to English. That's how this treaty was written between the parties. And so now, in 2023, we're being told by the Supreme Court, that it was really the responsibility of the parties to ensure that certain text was in that treaty in order for there to be a trust responsibility. And so we see the court kind of going away from treaty interpretation in the way that it's been set in precedents throughout, the past century. So that's definitely a disappointment for the Navajo Nation and for all of Indian country that this is the direction that we're continuing to see the Supreme Court go. Let me go on to the next slide. So again, this was a 5-4 decision, and of course the Navajo Nation agrees with the dissenting opinion that there should have been more responsibility put on the United States, and that history should have been taken into account. One thing that I also want to point out is that although the Navajo Nation is kind of seen as not the winner, we also see that the state interveners were not winners either, because the state interveners were wanting there to be a clear decision made that would keep the Navajo Nation from ever, what they called, from reopening Arizona v. California. Because our previous efforts to intervene were not supported, and that's something that actually this court points out is a possible path for the Navajo Nation. So talking about silver linings, I know I'm probably running out of time, but the Navajo Nation, of course, we were disappointed with the opinion. But a few things that we saw positive out of the opinion is that all 9 justices have acknowledged that the U.S. government does hold water in trust for the Navajo Nation. What that means after this opinion, we're not exactly sure, but we know that it still exists. The court ruling does not remove any actual water rights claims that the Navajo Nation has. The court's ruling does not have any effect on the nation's water rights to the Colorado River, and that although that there was not a finding of a breach of trust action, there are other opportunities for the Navajo Nation to continue its litigation efforts. And again, that was pointed out in both the majority and minority opinions. Also, let's see here. We also see that all 9 justices acknowledge the Winters v. United States case, which is the bedrock tribal water rights case for all of Indian country. And so we see that as being upheld. Both opinions, again, invite the nation to intervene and feature water rights litigation that involves Navajo water rights claims. And they also point out that, the Congress and the president, the executive branch, have a responsibility to assist the Navajo Nation with their water needs. And the opinions also encourage us to push for that through legislation to make good on the treaty obligations in our treaties. So until that time, until we are able to, have our water rights claims finally acknowledged and quantified, this is the reality of on the Navajo Nation, is more than 30% of our people still continue to haul water, and a lot of that is from the border towns. We also, I know Crystal will probably address some of how our people get water. So I'll switch to this. What are the next steps for the Navajo Nation? We're exploring our options. We're looking to the executive and legislative branch. We're also looking at the option of further litigation. And we're also, something that we did even before the opinion came out, is we are pursuing settlement of our water rights. in the 3 states. We have a settlement with the state of Utah and the state of New Mexico, and we're pursuing settlement with Arizona as well. So that is it for my presentation, and I look forward to answering some questions. Thank you.
Thank you so much, Michelle. I'm going to hand it over to Crystal before we open up for questions. And yeah, Crystal, take it away. Thank you.
Thank you for the opportunity to be here today. I think, when we talk about complicated issues, it's kind of good to orient us where we're at. So the Navajo Nation is the largest land-based tribe in the United States. It's also the largest populated tribe, and so it's here in the Four Corners region, straddling the upper and lower Colorado River Basin, but we have lands in Utah, Arizona, New Mexico, and we also have ranch in Colorado. And, we're similar in size to West Virginia or the country of Ireland, and primary water sources have been groundwater historically. However, surface water is an additional water source that we've been using to be able to diversify our water portfolio, and we've done that through securing water rights. And it's important to, what Michelle showed as far as pictures of people hauling water, and her description of the, percentage of Navajos that don't have running water here shows the 110 Navajo communities that are located throughout the Navajo Nation. The red indicate more than 200 homes that don't have pipe water. Orange is 150 to 200 homes. Yellow is 100 to 150, and green is 50 to 100, and gray is 0 to 50. And what you can see is in Arizona, we do have a large portion of those communities that don't have running water, and it's important for that to be known because there's a need to be able to secure their water future. But when you have challenges such as drought, basically climate change impacts on hydrology. So this is from the drought monitor, the recent drought monitor, and what you can see is that the Navajo Nation is experiencing abnormally dry to extreme drought conditions across the Navajo Nation. So we do have one mainland, but we also have islands of Navajo Nation bands. So just west of Albuquerque, you have the Tulley-Cordova band. South of Gallup, New Mexico, you have the Rama band. And then west of Socorro, New Mexico, you have the Alamo band. But, in showing our dealing with drought, it's important to look over the past 20 years. And what you can see is, we had a great, relief this past winter because we did have more than 150% of normal snow precipitation. But even with that, looking on this far right portion of the graph in the corner on the bottom, you can see that we didn't have, that didn't completely get us out of drought. We still had drought conditions, including abnormally dry and moderate drought conditions. But why do I bring these hydrologic conditions up? One, it relates to the Colorado River, water availability, the imbalance of paper water and wet water. But then also you think about who's vulnerable to drought. And when you think about who's vulnerable to drought in the Navajo Nation, that includes domestic water haulers, public drinking water systems, irrigators and dryland farmers, ranchers, wildlife, forests, plants, and recreation. So what are we doing to be able to try to do this? Basically create a secure water future for the areas that we do have secured water rights in. And so Michelle had mentioned that we have secured our water rights in New Mexico, and that's for the San Juan River Basin, which is located in the upper Colorado River Basin. We were authorized under Public Law 111-11 to build the Navajo Gallup Water Supply Project. The beneficiaries of that are not only the Navajo Nation, but also the Hickory Apache Nation, as well as the city of Gallup. And this is over 300 miles of pipe to be able to connect to the San Juan River system, which is a tributary to the Colorado River, and be able to, in the future, have upwards of allocations of over 30,000 acre feet per year to be able to provide water security for 43 Navajo communities. On the far eastern side of Navajo, we have the Cutter Lateral that's currently completed and providing water to 8 Navajo communities. And here's just a depiction of the laterals. This far eastern one is the Cutter Lateral. This San Juan lateral is here along 491, if you've ever been to Shiprock, New Mexico. This is just south of there. And then other stretches are under construction as well. And I just wanted to share that because I think it's important when you have decisions like what was Arizona versus Navajo Nation, to understand that, Navajo Nation is not just sitting, waiting for other people to do stuff for us. We're planning, we're designing, we're constructing projects to secure and sustain our water future.
Thank you, Crystal, for that overview. And now I would like to sort of open up for questions. A question that I had in particular about this, Crystal, and it looks like Michelle dropped off, but I'm curious about the idea of around prior appropriations, regarding water rights. For folks that are back east and live, I'm in upstate New York, so there's not much talk of water rights out here, right? And so I'm just curious about how prior appropriations work. And something that I've heard in a number of conversations is there's water that is available but because of lack of infrastructure, certain communities aren't able to obtain the water that is rightfully theirs. So I would just be curious to hear a little bit about that and about that particular challenge.
Yeah, so the Navajo Nation, so one thing to preface this discussion with is Native American people have been here for millennia. Through different archaeological evidence that can be proven. And so when you have the foundational document for the Colorado River that was signed in 1922 by 7 basin states and the federal government, but excluded Mexico and tribes, it's important to have an understanding that provides challenges, right? I alluded to the fact that there's an imbalance between paper water and wet water. As you read those foundational documents and all the documents that make up the law of the river, it's based on a water amount that's identified in policy. But when you think about what's provided by Mother Nature, hydrology, and the forecasted future by climatologists, a drier future, even considering aridification, people say mega drought. The droughts that we're experiencing, as research has shown, has been the worst in the past 1,200 years. So there's a challenge associated with that, and trying to be able to secure water rights for tribes that have been here, but unfortunately, the policies of this country don't acknowledge that existence and have challenged that existence, because that's the reason why we have resolved and unresolved water rights for the Navajo Nation.
Thank you. Thank you for that, Crystal. And I would this is more of a sort of a more of an aspirational question in regards to, again, as I talked before, about wanting to build that Beaver Bridge and thinking about water rights and the sort of the life of a river and the narrative of thinking about the Colorado River watershed. And this will mostly probably be a question for Joel, but I'm curious to just hear what other folks think is, activity happening in headwaters, right? And especially beaver activity in headwaters, like soaking water, holding it back. Joel, you mentioned about evaporation being a big issue relating to water rights, and a challenge is that water that's being held back and potentially evaporating. Does that always sort of lead to the conclusion that that's less water, or is this such a sticky question that it's still like the science is out on that?
Not having done a comprehensive review on the science of evaporation in wetlands, I'm not going to say definitively one way or the other. However, what we can say is that these wetlands that we're looking at are very high elevation, very short growing season. So the evaporative losses there are probably going to be pretty minimal compared to, say, a lower elevation reservoir, Lake Powell, Lake Mead, Navajo Reservoir, where there is substantial evaporative loss that is quantified. And so there's certainly a comparison to be made there, and that's something that I think is an open study to be doing, comparing evaporative losses high up and high elevations versus at low elevations. Where are we storing that water, and what's the trade-off there? But definitely, evaporative losses come up in Colorado because of our water rights system and how we track water and water use. But it's still an area of open study, I would say, for our region.
Thank you.
I would like to add to that. I mean, kind of personalizing it to the Navajo Nation with regards to beavers. I have seen, the evidence of beaver existence within some of our mountain areas and the perennial streams that we have up there, seeing the dams that have been built, the recharge that provides for the system. So I think when we think about water, sometimes, I mean, yes, we're talking about a lot about Colorado River today, but it's important to consider the whole water cycle. And beavers are integral to that water cycle because they help contribute an opportunity to create those recharge areas. And those instances that I saw, an opportunity for that water not to just run off, but to be able to sit there and naturally discharge that mountain area and just being able to, by also having that open standing water, an opportunity for evapotranspiration to occur, which then contributes to precipitation, which then makes the rainfall, makes the snow, helps recharge the ephemeral, the intermittent, the perennial streams, the groundwater. And I think all of it's really great that we can be able to have partners in our natural ecosystem that help assist us in that way.
Thank you.
Yeah, that was beautifully summarized, Crystal. And I think it's to your point of like, when we start talking about water rights and beaver restoration, it really focuses on such a narrow slice of what this ecosystem, what beaver mediated ecosystems do. So yeah, can't lose the sight of the beaver complex for the beaver pond.
Yeah, thank you very much, Chris. I'll concur. That was again the holistic way of looking at all this, right? Is the only way, and it's nice to have that in this space. I was wondering if any of you all have questions for each other. That's always the most exciting thing for me in these sort of panel discussions, is to open the floor to all of you experts who I know I've been learning so much from during this past hour. And I have some questions myself I'm going to move forward with, if that's okay. And we have some Q&As popping up as well. Let me just see here. Question here. Does water law in your areas make distinctions between naturally occurring dams and human-built ones? And that was said to Joel or to anyone, was that question was to.
Do the water lawyers have any thought on that? Our water lawyer here.
I'm a water lawyer, but I actually cannot answer that question. Sorry.
Having talked to a water lawyer about this, and it's going to vary state by state, but there is verbiage in water law referring to natural processes, a natural flow regime, and beaver are part of that natural flow regime. And so it's troubling to see, for example, a project that's going to restore beaver in an area that where they had been a decade ago or 2 decades ago, and to say that's an impact on water rights downstream when, in fact, the beaver had been there or are already in that watershed. So I don't know if there's court cases that are going to address that, or if future legislation is going to address that, but there's reference to it in water law.
Great, thank you. I guess trying to, returning to the theme of the future of water here and thinking about wetlands and about water rights. I just wanted to muse a bit with everyone in this room about what does a future look like? What does a resilient future look like? And thinking particularly about water rights in the Navajo Nation, a thing that I want to hold center here is what is a future where Navajo Nation and all sovereign tribal nations have access to clean waters? And how can people ally around this issue? Coming in as we do, people in this webinar right now, people come in from all over the place. And I just want to open that up for us to sort of consider and muse upon as a group.
The one thing I will add is, I mentioned that there's a decreasing water supply. That's the current situation that's continued to be forecasted for the future. And in that mindset, there's a lot of efforts pushed at various levels for conservation, while at the same time, tribes are still developing their water rights. And so, even when you think about water haulers, there's some of the most conservative water users right now. Using only 7 gallons per day. You think about that at a household level where in a city, it's over 100 gallons per day. But when you think about it, just to have that understanding, right? Like, why are tribes still pushing development? It's because we have such a large percentage of people that don't have running water or sanitation in their home. And so while there's this mindset of conservation, I encourage the audience members to also understand that there's still a need for development, especially by tribes who have such a large number of people that don't even have the luxuries that most Americans have.
Right. And I'll add on to that. That's a point that we have to make in our litigation efforts because, the current use, past use, future use are looked at in trying to determine what water rights should be quantified for tribes. And so the fact that, we have undeveloped water rights, it's kind of hard. It's like a guessing game when we're in actual litigation, which we are in right now in Arizona in the Little Colorado River. So we have to bring in experts who come in and, compare having to compare communities to others. And of course, we are unique and our situation is unique. But in order for us to further our claim, we have to, bring in this information, this data, and it's not easy to have such information or data. We even in litigation, have conflicts over what the population is, just because it's very difficult to gather, the information needed as a result of not just, the Navajo Nation being in a rural area lacking water, but other basic utilities, like, electricity, broadband, you name it. So it's very difficult to have that data readily available. And but what do we want our future to look like? We want our communities to thrive just like any other communities in the United States. We want our people to be able to be employed and to have economic development in their communities. We want children to be able to sleep well, eat well, so that they can get a good education. We want to be able to have a permanent homeland for our people so that we can continue as Navajo people with our own language, our culture, and so forth. And so we need water to be able to do that.
Thank you, Michelle and Crystal, for really placing us all with our feet on the ground with this context and to really understand the human rights issue this is, and that I'm really grateful and very fortunate to have y'all here, everyone in this space together to have this conversation. And to that point of a future, in thinking about wetlands, and going to bring Jeff and Christian back into this a little bit of what is that ideal future, right? In the midst of and in spite of the things that we're all facing, looking toward a more radical hope, perhaps.
I mean, there's a naivety right here. I mean, when we talk about water and somehow that if you don't protect those resources, you are gaining some sort of economic or rights issue. But the lack of having a holistic approach to water, whether it's water supply, whether it, wetland complexes upstream, I mean, it affects resiliency. So, I mean, flooding events, it affects, all things like water treatment and the cost of water treatment. And the more and more that we lose our watersheds and viable functioning systems, the more and more expense is going to be borne by the citizens at large. And I think that's a story that just hasn't been told, whether you're paying for your water in an urban scenario, whether you're affected by this flashiness that we're seeing with these climate weather events being so extreme, whether it's hurricanes without protection on coastlines, or just supply of water in general. All of those are going to cost something that are the current setup is that they're borne on society in itself. And there's some excuse that you hear with, changing or lessening of regulations that this is some economic disadvantage we're giving to landowners or entrepreneurs or whatever. And that's just not realistic. And I think my hope, or the brightness, the hope I have is that society as a whole sees that this is part of having a quality of life and a financial ability to be secure. If you don't have those water resources, regardless of where you are, it's not going to matter, right? I mean, it's the basic, it's the basic makeup of all of our lives. So I think that's the one thing I hope, is that we can start to tell that story better. And I know my years with EPA, we never told that story. We were never really allowed to express it in those views. And so hopefully, that's something that this group and others like it can get across to individuals.
Thank you, Jeff.
Not really anything to add to what Jeff had to say, other than just in terms of communication, just continuing. I mean, there's now even more so than ever an impetus to really stress the importance of less obvious ecosystem dynamics as they relate to freshwater and freshwater systems. Just because you do not see a source of fresh water visibly does not mean that it is not impactful. You have these ephemeral streams that are incredibly important across the country, but especially in the arid Southwest. You have these wetlands that are disconnected, that have all of their functional importance. And so just continuing to reaffirm that different sources of fresh water outside of the big major river is important, just not only to quality of life, but the surrounding ecosystems that they support.
Thank you. And recognizing the time, I with your brilliant minds here, I wish we could just stay on the webinar all day and ask questions. I know I would continue to learn, but I want to respect y'all's time, because you all are doing very important work. And I'm incredibly grateful to have learned today and to have brought up some of these questions. There are many more questions to answer and much work to do. And there are many ways to support these efforts. So please, I hope this inspires folks to be curious and interested to learn more about what's happening on the Navajo Nation and water rights in general, along with wetlands and beaver. I think the more spaces we have to share and for unlikely partners to come together, we really can weave a way of moving through the world where we're all better supported and understanding what other people's challenges are. So with much respect and gratitude, thank you so much for being here today and for being a part of us on our early iteration of programming. This is our fourth Beavers Uncovered, fourth or fifth, I believe. And on that note, I just want to conclude by saying that our next October edition, we'll be hosting another panel to explore the sustainable management of beavers for benefits of ecosystems, beavers, and human communities alike. This session is going to be on sustainable beaver management practices and trapping methods. It's going to feature and be moderated by co-curator Dr. Bonnie Gulas-Wroblewski and featuring Colleen Olfenbüttel, the black bear and fur bearer biologist from North Carolina Resources Commission, Joshua Tabora, a fur bearer biologist from Maryland Department of Natural Resources, Scott Beckerman, Illinois State Director of USDA APHIS Wildlife Services, and Arnie Groller, President of Wisconsin Trappers Association. And this is going to really be a space of plurality, right? Where we're bringing folks together who might not be together over some topics that might be thorny, but we are here to create a space for openness and connection and understanding. So, final note, we train folks to be beaver wetland professionals through our Beaver Corps training. Be sure to check that out. We have lots of subsidies and scholarships available. So if you want to restore some wetlands in your area and want to bring about the many plethora of wonderful things that beavers bring to an ecosystem, that training might be up your alley. And of course, we subsist and exist completely on donations, so feel free to support so we can keep these programs going. Again, much gratitude to the panel. I hope everyone has a beautiful remainder of your week and take good care. So goodbye and thank you.
Thank you so much.
Yeah,
Bye,
stay
thank
safe,
you.
everyone.